Senator Lee.
Thank you very much, Mr. Chairman, and thank you, Judge Garland, for being here today. I appreciated also your kind words about former Attorney General Ed Levy. I've been a lifelong admirer of his. He truly is an Attorney General in the grand tradition of that office, and he's someone who my family has known in one way or another for a long time. My late father worked for him while he was running the civil division during Ed Levy's time as Attorney General, and I've had close personal and professional interactions with both his son, David Levy, former judge and later law school dean, and with Ed Levy's grandson, David's son, Will, who served with me as my chief counsel, worked on this committee for several years, and later served as chief of staff to Attorney General Barr. So a big fan of that family, and I'm glad that he's someone that you look up to. I want to talk about a few issues today. Let's talk first for a moment about the Second Amendment and the right to bear arms. This is going back 15 years or so, but in a case called Parker versus District of Columbia, a case that later became known as District of Columbia versus Heller. As I recall, you voted for rehearing en banc with respect to an opinion striking down that same ban on handguns within the District of Columbia. And of course, later in the same proceedings of the same case, the Supreme Court struck down the ban. Can you tell us why you voted the way that you did, and why you voted to give D.C. another chance to defend its ban on handguns in that case?
Yes, Senator. As I know you know, because you were a law clerk yourself, you know that rehearing en banc is a vote to hear a case. It's not a vote on the merits of the case. And in my case, for myself, it's never a vote on the merits. It's a vote to rehear the case. The panel decision was the first time, I think ever, a court of appeals had held the individual right to keep and bear arms, which you are exactly right, the Supreme Court did uphold in the end. Every court of appeals had decided to the contrary, and the issue was plainly one that would require looking at a deep historical record as to the meaning of the Second Amendment and as to the way that it had been applied. I thought this was an extremely important issue, important enough since it was the very first time that we should hear it en banc. I was not the only judge, and other judges, including a judge appointed by a president of a different party, also voted, and for the same reason, so that we would have an opportunity to hear the case.
Thank you. I appreciate that. Let's talk a little bit about the meaning of the Second Amendment. How do you view it? And do you agree with Justice Thomas's analysis in his dissent in the Rogers case that the Second Amendment right to bear arms certainly includes the right to carry operable firearms in public for self-defense?
So my view is totally controlled by the Heller opinion. And in that case, Justice Scalia held that there was an individual right to keep and bear arms for self-defense. In the subsequent McDonald case, the court said that was a fundamental right, which applied to the states as well. It is a right, as Justice Scalia said in the opinion, like all rights, that is subject to some limitations. The court has not given us much more to work with at this point. And I do think, as I said with respect to my vote en banc, this is a matter that requires careful historical examination, which I have never done, and I certainly can't do sitting here for you. So I don't have an opinion on that question.
Okay. You've been in a judicial role for the last 20 going on 25 years.
Yes, sir.
You'll be in a different role, confirmed to this position, one in which you'll have a significant impact on policy. So let's talk about policy as it relates to the Second Amendment briefly. Do you support universal background checks?
Well, I do think that it's very important that we be careful that people who are entitled to have guns get the background check that allows them to have them, and that those who are not entitled and we are concerned about because they're threats, because of they're felons, or for whatever reason barred by the law, that we have that there is an opportunity to determine that they not be given a gun.
Do you support banning specific types of guns?
I'm sorry. I'm sorry.
Do you support banning of certain types of firearms?
Well, as I'm sure you know, the president is a strong supporter of gun control and has been an advocate all of his life, his professional life, on this question. The role of the Justice Department is to advance the policy program of the administration as long as it is consistent with the law. And as I said, so far we have a little indication from the Supreme Court as to what this means, but we don't have a complete indication. And where there is room under the law for the president's policies to be pursued, then I think the president is entitled to pursue them.
What about policies that would support holding firearms manufacturers liable for damage caused by people using firearms they produced to commit a crime?
I don't have I believe that the president may have a position on this question. I have not thought myself deeply about this. I don't think it raises a Second Amendment issue itself, the question of liability protection, but I have not addressed this in any way, and I need to think about this considerably more.
The other questions I raised potentially implicate the Second Amendment. That one raises other policy concerns.
I understand.
I understand that. Let's talk about FISA briefly. Yes. Senator Leahy and I have offered an amendment to reform the FISA process by strengthening the amicus curiae provisions that are already in there in existing law that have been put in there by, among other provisions, the USA Freedom Act, which Senator Leahy and I got passed through Congress and signed into law by President Obama in 2015. And our amendments would also require the government to disclose relevant exculpatory evidence, both to the FISA court and to the amici. This is an amendment that ended up passing the Senate last year by a bipartisan supermajority of 77 to 19. Do you support reforms to FISA, like those I just described in the Leahy amendment?
So I think FISA is an extremely important tool for the Justice Department and the intelligence community in general to protect the country from foreign agents and foreign terrorists. On the other hand, it is extremely important that everything we do with respect to FISA, and I have felt this way my entire professional life also, that we do so in accordance with the law and with respect for the constitutional rights of citizens. I don't know very much specifically about your two proposals. I do know the current rules with respect to amicus, and I have had the opportunity to discuss those with judges on the Foreign Intelligence Surveillance Court, and everyone seems quite happy with the way that process is going. I don't know what more might be needed. I would have to study that.
Mr. Chairman, I see my time has expired. I've got one very brief follow-up. Can I just finish that question? Thank you. On this topic of questions related to FISA, I also wanted to ask you, do you think that the federal government ought to be able to collect American citizens' web browsing or internet search history without a search warrant supported by probable cause?
I know this is a big issue. I don't, my experience with FISA comes from a slightly different era. I had a lot of experience, but it was very different era, and I followed this a little bit. I obviously haven't had any cases on it myself. I'd have to look at it. I believe in judicial review, and I'm a strong supporter of and respectful of judicial review of orders, but I don't know what the practicalities of going for a probable cause warrant in those circumstances would be, if there would be an emergency, et cetera. And I'd be eager to engage with you and other members of the committee who are concerned about this so that I can understand this problem more fully.
Thank you very much, Mr. Chairman.